Dear State Ocean Carriage, today I'm going to be talking about the situation referring to the damage of wooden beams, and in that respect, I'm going to be discussing the deviation liability and coverage in that particular situation. Now, we'll kick off this presentation by discussing what is deviation in this particular context. Now, under much case law, and notably the ETS Gustavi Brunet SAVMV Nedloyd Rosario case, deviation is defined as a departure from a contractual agreement, and in the maritime context, that comes also, often in the form of the bill of lading. Now, there are several forms of deviation. In this particular context, two of the most important, of course, being the reasonable deviation, otherwise known as justifiable deviation, and unreasonable or unjustifiable deviation. Now, talking about reasonable deviation, under Section 4 of the Carriage of Goods Sea Act, if the deviation is made for the purposes of saving or attempting to save life or property, it can be constituted that the deviation from the contractual agreement is indeed reasonable. Now, of course, more definitions to reasonable deviations are established in case law, and one of such definitions will be discussed further along in the presentation. Now, the second form of deviation is the unreasonable deviation, and according to Section 4 of the Carriage of Goods by Sea Act, deviation for the purposes of, for example, unloading cargo or passengers is considered to be unjustifiable or unreasonable deviation. Now, just like with the reasonable deviation, there are different and many other definitions for such term, and all of those definitions are indeed explored in case law. Now, is our case a case of deviation? Now, if we look at the bill of lading, it specifically states that the cargo should be stored below deck. Now, even if such mention was not given in the bill of lading, according to many cases, including the Britannica Inc. v. SS Hong Kong Producer case, there's always a presumption that if not stated in the bill of lading, that the cargo should be stored below deck. However, in our case, in the bill of lading, it was indeed stated that the cargo should be stored below deck, and therefore there is such obligation. Now, in our situation, the cargo was stored on the flat racks above board, which is indeed contrary to what was the obligation in the bill of lading, and therefore it could be constituted as a deviation. However, the more important question is it a reasonable deviation? Now, although most of the case law points that it would be an unreasonable deviation, including the ETS Gustave Brunet SA case, which states that storing cargo above board, unless explicitly mentioned to be stored above board, is an unreasonable deviation. Now, in our particular case, the cargo was stored above board, even though the bill of lading was stated to the contrary, for it to be stored below the deck. Therefore, it could be concluded, according to this particular case and many other cases, that this would be an unreasonable deviation. However, just like previously discussed, there are different definitions to reasonable and unreasonable deviations, and one of the definitions of the reasonable deviations was set in the Great American Insurance Company v. the MV Romreal case. Now, in this particular case, the court established that the performance of customary practice would constitute a reasonable deviation. Now, in our particular case, the beams were considered to be of unusual size, and for that particular reason, they were stored on the flat racks above board. Now, according to that, to the previously mentioned case of the Great American Insurance Companies, storing cargo that is of unusually big size on flat racks is a customary practice. And in that particular case, the court ruled that because storing such big machinery on flat racks was a customary practice, it was a reasonable deviation. And therefore, it could be constituted that since it was the storing of the wooden beams, which were of unusually big size on the flat racks, would be the performance of a customary practice, and therefore, according to the court's reasoning, indeed a reasonable deviation. and therefore it could be constituted in our situation that it is indeed a reasonable deviation. Now, according to Section 4 of the Carriage of Goods by Sea Act and the ETS Gustavi case, in addition to the Kia Steel Co. Ltd. case, in situations of deviation, the liability shall be capped at $500. However, there is indeed a set of conditions that have to be fulfilled for the liability to be capped at $500 per item or per product. The conditions for such cap are that the deviation is reasonable, and moreover that the bill of lading makes no mention of a value that is higher than $500 or any mention at all. Now, in our particular case, as established before, the deviation is indeed reasonable, and moreover, the bill of lading makes absolutely no mention of the price per product, and therefore, according to the Carriage of Goods by Sea Act and also case law, it could be considered that the liability would be capped at $500 per product. Now we're going to be discussing the review of the insurance policy, starting off with a grant, which is established in Rule 2, Paragraph 1 and 2, where Paragraph 1 essentially establishes that there is indeed an obligation for the insured to cover the insured. And then also we're going to be discussing the trigger, which is established in Rule 4 of the policy, where it states specific instances where at least what trigger events or circumstances can initiate coverage. Now, the most important question is whether the coverage is attained under the policy in regard to our particular situation. Now, for that, we have to look at Rule 34 of the policy, specifically at Paragraph 11, which discusses deviations and limitations in regard to deviations. And such paragraph states that deviation from the contractual agreement, where the right to the liability limit of $500 per product is lost, the coverage shall not be extended. Now, in our particular case, as established, it was indeed a reasonable deviation, and moreover, the bill of lading did not specify a specific number for per product. Or a specific amount or value per product, and therefore we have retained such a legal cap of $500 per product under the Carriage of Goods Sea Act, Section 4, and therefore by retaining such right or such cap, we do not lose our coverage, and the coverage is indeed extended, and we do not fall within the limitation paragraph of the policy. Now, finally, we'll be discussing dispute resolution under the insurance policy, which is established in Rule 71 on page 183 of the policy. And it states that any disputes between associates and members shall be resolved through the method of arbitration, and where in that particular instance of arbitration, both parties can nominate an arbitrator. This concludes my presentation, and I hope I have sufficiently informed you in regard to what is deviation, whether there is indeed a deviation in this case, what sort of deviation it is, what sort of liability is present, and finally, what is the cover situation in regard to the coverage and whether we are covered. And if you have any further questions, please don't hesitate to contact me. Thank you very much, and I thank you for your time.